lesser included. And so the guy's convicted of the greater, and then on appeal, they're like, well, there was really only evidence of the lesser, so we're going to reform it to the lesser. And that's fine. That's fine, even though the state objected to the lesser. And why is that fine? Because it's criminal. That is okay. All right. Indigence. The state does not have to prove ability to pay if the defendant's probation is revoked for failure to pay fines. This is very hyper-technical, whether it's a fine versus a court cost, because a court cost is not punishment, but a fine is punishment. But the court made a big deal of saying that they had objected under a different objection. So if your client doesn't have the money, say, Judge, we don't have debtor's prison anymore. I object under, I don't know, due process? Something. And the other thing the court held, ability to pay, which goes right along with this, it's all about the money. A trial court must consider a defendant's ability to pay for probation fees and services such as scram. And at the judges' conference, they were like, what does it mean, consider? I swear. I was like, well, you know, I think you have to hear some evidence that whether they can afford it, because like Judge Jani was saying, you know, these fees are high. A lot of times just don't have the money. Restitution. Owner's estimation of cost for restitution is sufficient. And this was pretty expensive. It was like $400,000. Like some building. They were like, yeah, that's fine. That's fine. And restitution can be paid to an individual unnamed in the indictment with proof of the loss offered. And this was a DWI, and I think like he hit like a car and a lamppost, and the car owner wasn't named in the indictment, but the car owner was proved, and so the judge said, well, you've got to pay that. In that case, though, they actually didn't have to pay because the defense maybe made an objection. I don't know. But just be aware of that the court said that's fine. Objection required over the amount of restitution ordered on probation. Okay, like that goes back 20 years. If you don't like something that you get or your guy gets on probation, if you don't object, then you can't come back later when they're revoked and say, well, I didn't like that. You better object when they give it to them. Object all the time under due process. Right. And this Texas Supreme Court case, there was a few dissents, Justice Willett, but you know, to prove you're an innocent owner for forfeiture, it's really hard. And I wanted to read TD, the prosecutor's website. They're like, oh, this was a bad case. That guy's a bad dude. They're like, well, but so take all his stuff. No, just take it. Take his car, whatever. Motions for new trial. You know, they used to talk about it be granted in the interest of justice. Well, the court has come out and said, but there better be a legal underpinning for this interest of justice. You have to have a legal reason why they're entitled to a new trial. In this case, the lawyer didn't call a witness. That was the strategy. On the motion for new trial, the appellate attorney was like, yeah, but that witness could establish innocence, but didn't want to go IAC because didn't feel like the lawyer was necessarily ineffective because of a strategy, even though it was a bad strategy. So they went interest of justice and won, but then lost. Court of Criminal Appeal, no new trial for you. All right. Newly discovered evidence on a motion for new trial passed. The Court of Appeals must consider all four of the factors. This case is unbelievable. This woman, like her mom called CPS and said, oh, she's, you know, abusing her kids. And so CPS comes and she said, and they take her kids, and she said, well, don't give them to my mother and my stepfather because my stepfather abused me when I was young. So what does CPS do? Gives it to the mother and the stepfather. So our lady goes over to discuss it, and mom and stepdad end up dead. And the state's theory was she made up that molestation. She made it up, and she got convicted and given life without parole. And then a guy read about it in the paper and said, oh, I dated her 30 years ago. She told me that. She told me that her stepdad molested her. And the Court of Appeals granted a new trial, and the Court of Criminal Appeals said, whoa, Nellie, you didn't consider all 4 factors. So they sent it back. They're trying to delay the process. Pleading the 5th, this is Stan Schneider and Casey's case. After the trial was over, the client had been told if he paid the restitution, he would get probation. When he went to pay the restitution, he had been giving all these $100,000 checks to his attorney. He was given 8 years in prison, and when they had the motion for the trial, his lawyer pled the 5th about where the money was. Allegedly, it was in Colombia. I don't know if that's true or not. But they said, well, the conflict of interest didn't happen until after. So he tried the case, and we don't know what he did with the money during the trial, but after, when he pled the 5th, well, that's the conflict after, so no new trial for you. All right. Proof felony murder from injury to a child must have an affirmative act, not injury by omission. That's an interesting, I don't see that very often, but I thought, oh, that's pretty good. We all know cell phones now got to get a warrant. McNeely in Texas, the Court of Criminal Appeals has granted review on several of these cases, so we'll see what they're going to say. If they think they have to follow Supreme Court precedent or not, it's still up in the air. We'll see what happens. And this is long, but this is on your paper. If you look on the Court of Criminal Appeals website, in the top right, they'll have a thing you can click for issues, and it'll show you all the issues granted, and that's a lot of fun, especially if it's some of yours. I love that. All right. This case, they thought this guy, someone said, I saw that guy do some crime, and so he runs to an apartment, and someone says he ran in there. So they run there, the guy comes to the door, the lady answers the door, she's like got a red face, and she's crying, and the guy goes, I know my rights. You can't search here. He closes the door. So they arrest him and remove him, then they come back and get consent from her. Oh, can we search now? Yeah. And of course, that's fine. That's fine. Because, obviously he had been beating her, her face was all red, so we have to search for any evidence of wife beating or whatever. It's actually something else, but the savings clause of sex offender registration must object at trial. That's one of the hardest things. I get some people calling me and asking me, does my guy fall under the savings clause? I have no, you've got to really study when all of that happened. But if you think you have a savings clause case, if you don't object at trial, it cannot be raised for the first time on appeal. So he might have had an issue that he didn't have to register. If you didn't object, too sad, because we know sex offender registration is not really punishment. It's just, just arbitrary out there. Mistake of fact. No mistake of fact defense for sexual assault of a child. I don't know why the court granted PDR review on that. They decided that 20 years ago. For you young people here, that's Romeo and Juliet. I saw that when it came out. Apparently, according to my mother, I stood up and said, look, Ma, they're bare naked. Pick one of the ones. You cannot be convicted of both continuous sexual abuse and of the criminal attempt to commit a predicate offense. It's like they don't have enough. It's like, we want to charge you with this, and this, and this. Just pick one. He's going down. Pick one. Speedy trial. We've seen a lot of that in Harris County with these cold cases. So I would look at those speedy trial cases. In this case, the guy, 6-year delay between arrest and indictment, he was denied a speedy trial. So I would definitely look at those cases. Dog alert. Okay, we know a dog alert can't give them permission to come and probable cause to search your house. But a dog alert can be used for sufficiency of the evidence to show, well, that money is related to drugs. And that dog is a very highly trained mutt that is my dog, and she wouldn't know drugs from, if it's alcohol. She's just like, it's something to eat. All right. This was an interesting case, Barry versus Spain. He's a contractor, and he took a bunch of money to fix up a house and then didn't do it. So they charged him with, misapplication of fiduciary property, and they're like, no, that's just a civil case. But in the prosecutor's notes, they put, don't worry, they have other charges against him that stuck. So don't worry, he's still going to prison. He didn't misapply the funds, he did some other stuff wrong. Okay, this case, the guy, they called the cops, he was threatening to kill himself with a gun. And of course, they charged him with resisting arrest with a deadly weapon because he was trying to kill himself with a gun. And the court's like, no, you weren't, the police officers were never threatened. Telephone harassment, this case is crazy. They said it just has to be more than one call. More than one. In this case, there were 6 calls, like the dogs in my yard, the newspapers on my driveway, and I guess there was a little bit of like some swearing and maybe some accosting in public at the supermarket. But 6 calls, okay, convict someone of telephone harassment. Waiver, you can waive your right to an interpreter. Did you know that? That case was down in the valley, and they're like, yeah, well, just because he couldn't understand anything. But our good friend Joe Connor's brother is taking that up on cert to the U.S. Supreme Court, and I think that's a very good issue. More waivers. Waiver of appeal does not mean you can waive your right to a motion for new trial. This is a good tip for you. Guy gets a DWI and gets probation. What does he go out and do? Gets another DWI. Now, in this first one, he got probation and waived his appeal. Then he gets the second one, but his lawyer's really smart and files a motion for new trial on the first one. So it stays the probation. And they said, well, you can't do that. You waived your appeal. He didn't waive his right to file a motion for new trial. Boom. That's the case for us. I don't know how that slipped through. I have no idea. Oh, that's it. All right. Thank you.
Really briefly, the 2.0 hours of ethics begins tomorrow morning, and that will be 11 to 12 and the 12 to 1. So if that's what you need, that's when you need to be here. The paper that's being referenced in all materials will be emailed at the conclusion of the paper, so don't worry about that. You'll get it. Just make sure you get your email address. 11 o'clock, we'll see you tomorrow.